Roll call, please.
Chair LaFaro.
Present.
Vice Chair Finnerty is absent. The Secretary is present. Board Member Catalinato.
Present.
Board Member Mutu.
Present.
Board Member Neely.
Present.
Board Member Fulham.
Present.
We have a quorum, Madam Chair.
Thank you. Please join in for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Minutes, Gloria, anything?
Yes, we do. April 28th and May 12th.
April 28th and May 12th. Motion to approve.
Motion.
Motion by Craig, second by George. All in favor?
Aye.
Opposed, abstention, 6 in favor, 1 absent. Okay. So we're moving to number 1. Claire, the Long Island Resources Corps.
Yes.
Okay. John, are you the applicant on this? No. Yeah, you can come up. It's much easier for the audio and for paperwork, we've decided.
Hey, John.
Claire, go ahead.
Oh, yeah, I just want to give a brief introduction, and do you want plans? I have some plans I could pass out to you, too, so I'll do that in a
Sure.
second. But this is the former Pier 1 building. It's been many things over the years, but it's about 19,000 square feet.
Way back.
My
It's
generation.
way before my
Aren't
time.
we all?
The
I
nightclub.
remember.
It was a nightclub, so that was more fun. And so now it is a furniture store. Colette's is in there. And this is the proposal to do a site plan special exception for a motor vehicle sales for Tesla specifically. They're proposing the use and some upgrades to the exterior of the building. So this is the aerial, and if you remember, the planning board had reviewed the one on the corner, which is on Flying Point Road and Montauk. This is called Flying Point 1 and 2, and with that facilitated the cross-access, which really makes this property accessible to a light and safe egress and ingress to the property.
Has that been opened up? The
It is
last-
opened up. I drove it. It's
Oh, good.
great.
Okay.
It needs a little TLC, but it's very functional. It's great.
Perfect.
Yeah.
Great.
So it does make this a good application for accessibility. So I'm going to have the applicant speak, but I will put up the elevations so you can take a peek at it, and then I'll give you them too.
Oh, it's John Bennett, and Lisa Poirier is here with me as
Okay,
well.
just for the record?
Yes, John Bennett, 212 Windmill Lane, Southampton, New York, for the applicant. Lisa?
Lisa Poirier, Twin Forks Permits.
So this is, having handled a lot of automobile dealership matters over the years, one thing that's great about these sites is they're not big traffic generators, because, you don't buy an automobile every day.
Or Tesla.
Tesla.
Especially a Tesla.
Yeah. Or a Mercedes or a
Yeah.
Lexus for that matter. But,
Yeah.
and of course, the service involved, but not the same, probably not to the same extent. So the site, complies with all the requirements for a special exception. As I always remind everybody, these special exceptions, they are a permitted use that is permitted upon special exception. So it's been a finding by
Claire?
by the town board that this is an appropriate use, assuming we meet the standards and it has checks off all the bells and whistles. It's close to a traffic control device. Obviously, you're going to limit the certain manners of ingress and egress. And what's great about that is the forward-thinking planning and some of the lots to the west really help that out. One of the things that I know the board has been understandably concerned about over the years with automobile dealerships is those pesky deliveries that sometimes park themselves in the middle of the street. And the nice thing about this is that's not going to have to happen at all. We have plenty of room for the turning radius, and you'll obviously prohibit that as one of the conditions, and that's not going to be a problem. Even in the places where I've seen you say that it can't happen, it sometimes
It
happens.
sometimes happens, it's true.
It's a difficult thing. The nice thing about this is it's close to, having studied the industry standards, this is actually closer to the minimum size that the industry likes to see for an automobile dealership, for obvious reasons. So, I don't know, I think.
John, will they have charging stations?
Yes.
There will have charging stations in the rear of the building?
And will they be building some kind of repair bays in there?
Yes, well, there will be, again, it's when it comes to, I'm really at the end of my knowledge, which is a very small envelope in terms of
Right.
electric cars, but my understanding is that that it's sort of like a quantum leap in terms of,
Right.
between that and the internal combustion engine, in terms of the amount of.
No oil, no gas to deal with?
You may know more than me. I guess you have to lubricate
we
the
did-
thing somehow. but-
When I was working for the town, I was helping purchase, and we did purchase some electric vehicles, and the maintenance is kind of cleaner, if you will.
Okay.
You're not dealing with oil or
Well, I know
gas. you
my
know.
son has a Tesla, and they come and service it in his driveway.
Oh, okay.
So maybe it's going to be a base as well from which they.
I think we want to have the ability to have on-site servicing, but again, my guess is that it's much less complex, and, although I don't know, to be honest with you. That's just my
We're all learning.
presumption.
Yeah, will the building footprint be similar to what the current building is?
There's no change
There's-
at all.
okay.
We're not increasing the footprint by 1 square foot.
Because the photo, the rendering,
This one,
yes, it kind of
Oh,
looks,
here.
looks,
Is it a
well,
little bit less? Oops,
This one, John.
Sorry.
yeah,
The paper, as
They're
always.
changing the facade.
Okay.
Yeah, but
building.
not the.
You're not knocking the building down.
No,
No, no,
no,
no.
no. They're changing the facade of the building on the front and then the rear to fit into the Tesla branding model as far as a dealership. And they're not going to have necessarily cars that you can go there and test drive. They'll have a couple models there for you to look at, but the way they set it up is you have to go online and actually purchase the car. So you can't go in there and actually sit down with the salesperson and buy a car from them.
Now, I've had this
Right.
conversation with the Tesla people, and I get a lot of, I'm thinking, no, that's our model, that's our model, that's our model, that's our model. But I think that may change. So you have to assume that, and again, I'm sure if they're listening, they'd be.
Maybe
But
they'll change.
from a land use point of view, I don't want to make a representation that there'll never be on-site sales there. I've been told that's not in the program, but I think it's
could
only
change that.
common
Yeah.
sense and
that's-
stuff that
that-
we all
that's
deal
been
with.
the-
I don't have to come back and say, now I'm going to have,
Right.
so.
I mean, my understanding is that is their model.
Yes, it is.
And they don't have dealerships,
Yes, but,
the way normal car dealers are.
no, that's very true, but
I mean, that's just from public reading.
Right.
absolutely.
Yeah, the centers are really more of a showroom than a dealer.
Yes,
at
they're
present.
truly a showroom. And I've gotten a little bit of blowback from the client when I've said, I'm going to, tell the board, though, this is the current model, and they say, no, this is our model, this will always be our model. But things change, so, I think you have to anticipate. And it's not a problem, because it meets all the standards, but certainly there may be at some point
But the
on
closest that the
premises.
town use has is a car dealership.
Yeah, the closest,
Yeah, I mean, from an aesthetic viewpoint, I would like to have seen a lot more greenery
okay.
on the road. I mean, 'cause it's not there now, and that whole strip is kind of ugly.
Well, the only
From-
thing I would
from
say
an
to that is, we'll take a look at that, certainly, and we'll work with the board on that, but,
Some street trees,
yeah, but
they help
part of it is,
create shade.
They
part of it is the visibility.
Exactly. I understand that, but it's,
Well, we'll work with that.
Either
We'll work with
side,
that,
right.
yeah, yeah.
And I just had a comment on the
Sure.
facade piece. I
Yes.
know there is a rectangular section there now, but if this could just be a little more refined, I mean, because the car is so exquisite, that the bulk of this,
Jackie, this right
Yeah.
here.
Yeah,
This right here.
exactly.
Okay.
exactly,
Try to make it a little bit more,
more refined.
like it,
yeah.
more like it fits with the community.
more like,
More like it fits within the community.
fits-
what, I'm sorry.
fits in the community. It's sort of a very
This is a
modern,
combination of me at 66 having some slight hearing
and the mask. Yeah, I'm trying
Yeah,
to
but
articulate.
how you're modifying the word community?
I said so that it fits in
Oh,
with the
fits,
community.
fits. Oh, fits.
Sorry.
I'm sorry.
Yeah.
I'm sorry as well.
Um,
Okay, yeah, we get it.
Yeah,
You know.
I think,
I mean,
No,
the
I
car-
remember years ago that what's now Jaguar, and we did the Jaguar and Land Rover, and for a while, GM had a car that they had a line, but then they discontinued. It was like this separate, I'm trying to remember what it was called. Does anybody remember? It was a, anyway, the long of it, they wanted to be what, such and such of the Hamptons, and we were, no, make it of Southampton. It's just that sort of subtlety.
Yeah.
little
And,
change.
and the board and the village greatly appreciate it. I'm trying to remember what they were called. It was about 15 years, the GM had a line that was a separate line, and separate dealerships and.
Yeah.
We're dating ourselves.
Yeah, I know. But yes, I'll.
Better than 30, better than 30 years.
I would assume that being Tesla, are they planning to do like solar roof, solar tiles on the roof when they do it? Or
I don't know if the
I don't know about
retrofit
that.
includes that, but that's
battery
one of their
storage-
products.
Battery storage on the, for
We'll find out.
I
backup.
think that, yeah, that.
I mean, just again.
Certainly in the rear of the
I mean-
building, maybe they can do something.
It's
'cause
suitable for
this-
the building size to, to.
Yeah.
I mean, that's one of their, that is
all
one
their
of,
products.
that's one of their products,
And
yeah.
if you could find out about whether they are going to be putting in repair bays of
Okay.
some sort in there.
They are doing service bays inside.
They are, okay.
Yeah.
I was just looking at the
There is a
pictures. I
site
didn't
plan
see
in-
that shows it. Okay.
There is
Is there a floor plan?
this
Does show it
package,
there.
Customer lounges,
Customer lounge is.
the last page of this,
Okay.
that package.
There we go.
We're going to talk to them
The
about
final page has,
some gentler screening as well.
Yes.
Because it is very bad, that whole stretch
Yeah.
is.
Is that whole search
Whole
is kind of
automobile
not
stretches.
very attractive. I guess my other question is that currently Tesla's charging stations, no other car can use them.
Oh,
And my understanding is they are working on changing that. And if that is the case, will those charging stations be open to the
yeah,
public?
I couldn't commit to that now,
I'm
number one.
just asking the question.
Yeah, I can find that out. I can find that out, and my apologies. It's just the lawyer in me, and the land use lawyer. That wouldn't be an appropriate condition but I can find out.
Well, it could be a community benefit.
No, but it wouldn't be an appropriate condition on a permit.
Okay.
You can ask your counsel.
Yeah, I'm not,
Yeah, that would be, we will find that out.
yeah.
though.
I
We
mean,
will
I
find
know
out.
that Tesla put in charging stations in Montauk
Yes,
on East Hampton Town property.
yes.
And the East Hampton Town Board required them to pay for regular charging stations as well.
That's because it's on
It's a municipal property.
the
Yeah.
municipal
Yes.
property.
Yeah, 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 yeah.
But that's where I was, that,
That would be tantamount to, I can tell you right off the bat, and your counsel will back me up on this, that's tantamount to when East Hampton many years ago tried to say, on trails, we're going to have, okay, we're not going to say that you have to make it open to the public, but you have to file something called a non-interference agreement on the trails. And the court said, well, that's essentially an easement open to the public. So you cannot condition a land use permit on providing access to the public, which that's.
It's on
that's what
private
that would be.
property.
It's on private property.
Yeah, I mean-
I will make the inquiry,
yeah.
though.
I'm
And I understand
I'm
where
not
you're
an
going.
attorney, but I am co-chair of the Town Sustainability
Your
Committee.
counsel will tell you
So
what I
I'm,
just told you.
I'm looking out for
You've mellowed so
the community.
much.
Excuse me?
You've mellowed so much.
No,
What we're
I
trying,
remember a time when you were.
there's no sense getting upset about black letter law. It is what it is. So.
when we're looking at parking spaces now in larger site plans, and we are very cognizant about including some charging stations, generic charging stations.
Yes.
Because it's happening, you know?
Okay,
Yeah.
that's very
So
good.
it was just
But again,
curiosity.
We'll make the inquiry. We'll
Good.
make the inquiry.
Anything else on the board from
Well,
this?
And I just, again, and I think George mentioned it, with the repair facilities, I think information about how many batteries are they storing there,
Right.
things like that.
Yeah, good question.
You know, electric batteries do have, some concerns and safety concerns.
Oh,
If you're storing electric batteries
They,
in the property.
fire,
potentially a fire.
fire.
Yeah, safety.
Right.
Yeah, we've been dealing with battery storage applications, so we've learned a lot.
This is like at the end of that movie with Tom Cruise and where the guy's got the battery that is about this big but stores everything, but they haven't figured out how to control it, and the bad guy runs away with it and explodes.
The whole globe, right? Okay, so we want to set a pre-submission conference date, Claire?
Yeah, and right now I'm suggesting October 13th because I think that September 22nd has 4 items already.
Okay, so
So-
October 13th, good? Okay. Anything more?
No one wants to
Hearing
do
none?
too much work in
October
September and
13th.
then transition back to the real world. Right? So October's fine.
Could I have a motion to set the public pre-submission conference October 13th by Gloria, second by Kate, all in favor? Opposed,
Thanks a million.
abstentions, 6 in favor, 1 absent. Thanks, good to
We'll
see
get that
you.
info. Good to see you. We'll get all that.
Thank
all
you.
the questions.
Thanks,
Thank
Lisa.
you, I appreciate it.
Jeff doesn't have the one, so we'll let Jeff know that. Thanks, Claire.
Okay, Jeff, where are you? Number 5?
Number
Waiv-
4. Or, actually, no, number 5.
No, it's number 5, Waverly Place,
Yes.
consider completeness.
So we have an application that was presented to our office, pre-application titled Waverly Place LLC, which proposes a two-lot subdivision on a 4.133 acre lot. Currently improved the single-family residence and CO'd with an accessory art studio. That art studio, based on the original COs, used to be a single-family dwelling, but was converted to an art studio when the new residence was proposed for construction. The lot itself is located in CR 80 zoning district, also within the New York State archaeological sensitive area, and also in a POD, or overlay district. The address for the subject property is 965 Head of Ponds Road. So we are presenting this for consideration for completeness. Recommending the application be deemed incomplete. There's some number of items missing from the plan. Because it's in Aquifer Overlay District, we're requesting that the applicant provide us with clearing, proposed and existing clearing calculations. Also recommending an existing 8-foot fence on a property, either reduce it as it doesn't comply to the Town of Southampton zoning code. Also, if you can remark from the aerial, there is a wooded area or a highly vegetated area that's not marked on the survey as well, so we kind of wanted to take a look at that. Of course, preserve as much as possible. So, I'm recommending that we consider this incomplete.
Yeah.
I'll leave
If
this to
you
the
could
board.
just identify where another cross street might be on Head of Pond Road?
Oh, Cross Street, Blank Lane, actually,
Yep.
is to the left or to the west of Whispering.
Okay.
Thank you. Just helps me
Or you
place
could-
it
Perfect,
when I've driven past it.
awesome.
Okay, no other questions deemed incomplete. Wayne, did you want to make any comments or no?
No.
Okay. Motion to deem this incomplete
Motion.
by George, second by Gloria, and all in favor.
Aye.
Opposed, abstention, 6 in favor, 1 absent. Okay, we're going back in order. Thank you, Jeff. Anthony, number 2, Hampton Bays Fire District and Good Ground Commons.
So the board will remember that we've been looking at the subdivision, Hampton Bays Fire District, Good Ground Commons. Just a reminder for the board, the properties in the Village Business Zoning District along Montauk Highway in Hampton Bays, just to the west of Squiretown Road. State-owned drainage basin sitting up here. Board might recall, take a look, clockwise. I always do these color things. The property as it currently exists, and then, or the property as prior to the subdivision, I should say. And then the plan is to break it into 3 lots, if you recall, with the 3, let's see here, 1, 2, 3. We had indicated that even though this didn't have direct road frontage, we were going to accommodate access to this lot via access to the property to the west. Property here is being retained by the fire district. This one here as well, and then this is the other property, I believe, that Wayne Bruin represents. We had looked at a pre-application report on this before, and we've been extending it. Let me just do this here. A number of times. Now, as the board knows, one of the big issues, and I'll go through it real quickly again, the pre-app report was because these are village business zone properties, we were talking about cross-access that we would normally require as part of a subdivision when we're looking at future site plans. I know the fire district's attorney is here, and they've raised concerns and issues about the cross-access, and they've raised objections. You were forwarded information from the attorney who outlined, and is here today to speak to the board regarding those issues. But just to go back to the original comments and recommendations. Again, the first one talks about, well, let's see here. Make sure I got it. Yep, the cross-access among the properties. Let me go into detail here only because it was part of the town's long-range planning for the downtown of Hampton Bays. So, you know, we identified the need for the cross-access, what the intent of it is. Number 2 talks about that property that we talked about that comes to a point that didn't have direct road frontage. Number 2 just talks about the access being accommodated on a property to the west, and we would need the relief from the zoning board because they don't have direct road frontage on the one lot. So we noted that. Number 3, we noticed that we recommend talk about on the fire district property that's being retained by the fire district. There's an existing garage. What we are saying in here is, I don't mean to imply that they need to go to the zoning board per se, or they need to remove the garage. I'm pointing out there's an pre-existing structure on an existing lot. That lot is changing, so I don't know what that means for the purposes of the town's zoning. So I'm just simply recommending really that the applicant confirm with the building department if anything needs to be done to address that. The building's there, it doesn't really impact anything, we're not changing anything, but I'm just pointing that it exists on a lot that is one configuration. The result of the subdivision is it's on a lot now in a different configuration. So I'm merely pointing that out. And then number 4, just because we were addressing comments from the Conservation Board, the drainage basin is not a regulated wetlands, and so it wouldn't be subject to buffers or anything like that. But I really think that the big issue was the cross-access, I think.
Yes,
and
it is.
And I want, I think the applicant's, the fire district representative.
Right. Mr. Orzechowski?
Gloria had a question?
Yeah, I just, remind me that it's a dual application, but they're separate owners for those pieces of property?
Yes.
And so I think it's Lot 3, which is the furthest east,
Yes.
that is,
In question?
who owns that?
Wayne wants to come up, I think.
The yellow.
That's the fire district.
Wayne, you can please use the table in front of us.
Okay. So Wayne Bruin, O'Shea, Morsensic Bruin, for Good Ground, Inc., and Stan Orchowski is here on behalf of the fire district.
Stan?
Looking at that map, the yellow and the orange stripe are parcels retained by the fire district, and the red stripe is what was conveyed from the fire district to Good Ground.
Thank you. It just,
Okay.
it was
Thank-
getting muddled in my head.
Mr. Orzechowski, we received your letter, and
Thank you.
I want to give you the time to go over the pertinent points
Thank you.
so that we can further examine this application.
I'll unmask if that's all right. Jim, you may
Sure,
not be able to
yeah.
hear me.
Yes, I know.
Good afternoon, everyone, and thank you for your time. My client, Hampton Bays Fire District and Fire Departments appreciate the opportunity to be heard. We also, I personally wanted to again extend my thanks to the board and to Mr. Trezza for all the work that has been done on this matter and the accommodations that have been given to us with regard to rescheduling. Thank you very much. With regard to the efforts that have been made, the reason I penned the letter earlier this week was really to try to not only bring everything current, but to give the proper overview as to everything that brought us to this point and all the efforts that have been made, particularly by Christine and by Wayne and myself, to try to see if we could reach agreement with regard to the cross-access issue. So it's not a matter, and I didn't want the board to have the impression that we were just letting this ride along without giving it attention. It really has been given quite a bit of attention. The points that I outlined, excuse me, in the letter, in terms of legal objections, I wanted to amplify those, which is another reason I wrote the letter. Those are major concerns because the declaration of easements and covenants that was proposed, it was well-intentioned by Wayne, as I said in the letter, but it was fashioned after prior similar agreements that did not involve municipalities or fire districts specifically, which have these additional obstacles with regard to the use and the disposition of their property. So the points I've raised, particularly with the controller's opinions and other points in the letter, are major, in my view, major impediments to us being even in a position to consider entering into a declaration of easement and covenants. I also want the board to understand and make no mistake about it that the district, when it sold this one parcel to Mr. Kiola and to Good Ground Commons back in 2016, entered into a contract where we agreed, and we've done everything to this point to cooperate with the subdivision application. But our concerns at this point are not only the legal concerns with regard to being asked to enter into a declaration whereby we would actually be gifting a real property interest to a number of entities or individuals, but also doing it without a public referendum, as was done when the lot was sold to Mr. Kiola back in 2016. We're also concerned from a safety standpoint, a public health and safety standpoint, as I detailed in the Chief Capers affidavit, with regard to how this might develop. If cross-access is permitted, if it were to be situated across lots 3 and 2, and if the declaration of covenants would really be sufficient to prevent vehicular traffic using such cross-access from then traveling north and south out to Montauk Highway, number one, and number two, possibly impeding the fire department in terms of their being able to have access over Lot 3 to get to Lot 2 in the event of an emergency. So I asked Chief Capers to sign the affidavit because those are legitimate concerns in terms of public health and safety, and also because, we've said all along we objected to access from Lot 1 and Lot 3 onto Montauk Highway. I wanted to make it a little more concrete in terms of understanding what those concerns would be. The other point I wanted to make to the board is that with regard to the declaration Wayne had drawn, it provides that it would go into effect now, but it would also put us in the position of, down the road, when we're at the site plan stage, having the opportunity, as was discussed with Christine and Wayne, of a hearing where we could voice our objections. But my concern was that at the outset, in the declaration as drawn, if we entered into the declaration now, we could be heard at a public hearing. The site plan might be approved, the covenants in here would be enforced, but the provision in the covenants with regard to no traffic entering from Lot 1 or Lot 3 onto Montauk Highway might or might not be enforced. Might or might not be enforced. That's a concern for us, because who then would have to shoulder that responsibility to enforce it? I think it would be my client. And that's a position they don't want to be in. Also, they don't want to be in the position, as I mentioned earlier, of having access along Lot 3 to get to Lot 2 in an emergency to be impeded by vehicular or other traffic that might be coming across Lot 1 or Lot 3. So my point is that my client would like to see the subdivision move forward, but they really don't feel they're in a position now that they can agree to a cross-access agreement. And we say that not just for the reasons I mentioned, but we understand and we appreciate that there's been litigation recently. I mentioned it in my letter, the Lombardi case. And that's an important case because not only did it make changes with regard to the changes that were made to the code previously in terms of annulling it, and in those provisions that were annulled, there was this requirement for a continuous or additional public access to parking between and among lots and additional accessibility to the street parking. In that agreement, or rather in that decision, it states that with regard to the analysis done under the State Environmental Quality Review Act, available parking is underutilized as it exists now, and there was not sufficient showing with regard to the need for the additional access in terms of parking between and among the lots. That's not to say it's not a legitimate concern. I'm sure it is. All right, but that's been changed. I'm sure it's being reconsidered. The town and this board, as a matter of policy, still wants to consider that issue, and I understand that's a legitimate issue. But with my client as a municipality, I think it's a different situation, and I think we're really just not in a position right now to agree to the cross-access agreement.
Just because it's been a bit since we discussed this, it was a while ago. Were you okay with pedestrian east and west and not north and south, and vehicular east and west and not north and south, or neither?
Neither.
Neither.
Neither. And we did discuss it. It was back on
A long time ago.
St. Patrick's Day. And that's not the reason I remember it, by the way.
Well, that was one of my questions. In other words, when you sold the property in 2016, were there easements in place, and did it include pedestrian access?
No.
No.
The only easement that was in place was the one that Mr. Trezor mentioned with regard to the recharge basin for the state of New York. That's a perpetual easement.
Right.
That was not affected at all by the sale.
Okay. So, in reading your letter, it says that as a matter of law, the district, as a matter of law, preempts and violates the property rights and interests of the district and its residents. So that's really a strong basis for not being able to enter because you're prohibited by the district.
We're prohibited by the state law at this point because we have not, we would be asked under the agreement to basically, without any consideration or any compensation, to basically transfer a real property interest, which in the controller's opinions, which I attached, indicate that is something that cannot be gifted. The second thing is that even for that transaction to be considered, it would have to be put to a public referendum and approved, just as we did when we sold lot number 2 to Good Ground Commons back in 2016. So we can't just sign the agreement. It would be nice if we could, but we just can't sign the agreement saying we'll grant easements to everyone, non-mutual, pedestrian, vehicular, and so forth, coming back and forth. We just are not in a position to sign an agreement that just automatically just conveys those interests.
Okay, so just in order to understand this,
Sure.
because it does get complicated.
It does.
Are you saying that the easement has real property value and that it should be compensated for if in fact you convey it?
As a matter of fact, yes, I am saying that because under the controller's opinions, and actually under another case which I had researched, but I thought the letter was well long enough, I didn't want to go on.
We like case law.
There was a case back in, that I found back in 2017, which involved the Bridgehampton Inn. And there was a site plan that was considered, and there were similar access requirements imposed with regard to the site plan. And I don't think it was the Bridgehampton Inn, but I think it might have been an adjoining landowner brought an Article 78 proceeding. And the east access, I believe, that restriction was annulled. And on the west access to the property, it was sent back either to this board or to another board in the town to further reconsider it. And the way it was resolved is that the Bridgehampton Inn and the town and the other necessary parties considered it, and there was an agreement that was entered into, and I believe you may have been involved with it. It's back in 2017. But there was agreement that was reached, and again, that didn't involve municipalities, but there was an agreement reached whereby there was compensation paid for the access agreement because of its value and because it's a real property interest.
Interesting.
Yeah, and I have a copy of it here. I can forward it to everyone of the board resolution on that matter. I don't have the actual decision from the Supreme Court case, but I have the board resolution from 2017, and that's how it was resolved.
This is the first time that I'm seeing this because I'm new. So just for a review, in 2016, this whole like backward C-shaped parcel belonged to the fire district. Is that correct?
Yes.
And then portions of it it was subdivided and portions of it were sold.
Yeah,
Wasn't
portion of
something-
it, the north lot, which is lot 2,
Yep.
which then comes down and then
The
arrows
red.
out at Montauk. That's all lot 2.
Okay.
That was sold to Good Ground Commons.
Got it. Okay.
They're back
And
here
the
to get
yellow-
subdivision approval because it was sold without a subdivision approval.
Oh, okay. How did that happen?
It happens.
Okay, okay.
It does,
Good
it
to know.
happens.
And then the yellow hatch marks, can you just reiterate the current status of those for me, just so I can make sure I have it correct?
That's fire district property.
Okay,
And on that property, close to Montauk Highway, about where the hand is right now, is a garage. That's the one that Mr. Trezor was referring to.
okay. And the other,
The lot number 1 is also the district's property.
orange. Yep.
And
So,
as I mentioned in the letter, when I was working on that transaction with Chris Kent, also a very distinguished land use attorney, as is Mr. Bruin, we agreed, as I said in the letter, in terms of how Lot 2 would come to that point at Montauk Highway. Again, one of the concerns, even then, was access of vehicular traffic to or from, in terms of those lots being on Montauk Highway. You know, if you know the area at all, and I'm
I
sure
live
many of you do, okay? 69 West Montauk Highway, the firehouse is right across the street.
yeah.
So when they need to get in and out, they need to get in and out.
Yeah.
Yeah.
So is it my understanding that when the property was sold, when you sold it to Dwayne Bruin's clients,
Yes.
there was no access? It's sort of landlocked?
Well, what the plan was, and I don't want to speak for Mr. Bruin or Mr. Kent, but I can speak generally.
Yeah.
The plan is that Good Ground Commons, the entity that purchased Lot 2, was also acquiring, either purchasing lots to the west or obtaining easements with regard to lots to the west, so that they would have access to
Through those.
Montauk Highway.
Right.
And as was mentioned in the report and in the comment, legal vehicular traffic to and from Lot 2, because of those steps, is in place, is adequate, is sufficient. What we're talking about is cross-access between that lot and Lot 3 for whatever reasons.
Are you saying that the district would consider this if it were being compensated and obviously then went through the process, but they would consent to go through that process if they were properly compensated, whatever that means?
I don't know if they would, if it's, I'm
just asking what your position
I don't
is.
want to say it's just on that, all right? That certainly would be an issue, but the other issues in terms of safety. For example, if there were cross-access across Lot 3 to Lot 2, and if it was...
North and south?
No, east and west.
East and west?
If there was east and west, all right, and it's my understanding that, and Mr. Bruin can speak to this, but it's my understanding that Good Ground Commons had planned, maybe they still plan to develop Lot 2 in terms of commercial businesses that may operate there. So obviously, they would then need vehicular access, which they have, to Montauk Highway. But if they were to have that, and there were to be east-west access for vehicular traffic going to those businesses, that would be a concern. Because as the chief mentions in his affidavit, the department needs a way to get there if there's an emergency. And they would go, directly up Lot 3, if need be, to get to Lot 2 and render their emergency services.
What's next to, on the east side of the yellow lot?
Yeah, it's good ground.
There's a lot there, I think, which is owned by Good Ground, or might be Kiola Realty Group, I'm not sure.
This lot here, Gloria?
Yeah, I mean, I guess what I'm questioning is where does the cross-access go? What value does it have?
The plan, if I may, the plan, as Mr. Trezza mentioned, as I think we have discussed, I believe in our conference call, I know I've discussed with Wayne, if there were cross-access, it would be in the north portions of Lot 3 and Lot 2. North, I think, north of the recharge basin. Right.
And really, it's the Gloria, it's part of, the connectivity along the highway of commercial properties where we try to get the...
Yeah, but it looks like there's an awfully long way to get to the first north-south street.
What do you mean?
The plan of she's saying right now, it's
Right now.
far
Oh,
away.
right now.
to get
Yeah,
it, But the
yeah.
plan would have that.
There's an awful
all-
lot of other
if there
property
wasn't-
owners
Yeah.
between the yellow lot and, what is that road? Is that,
It's Good Ground
Good
Road.
Ground.
Anthony,
It's
do
good.
you have
Right?
cross-access
Where the
or
park
anything
is.
yet?
Yeah.
That I
well, I know where the
probably
park is.
not,
That's further-
Christine, to be
that's-
quite honest.
That's further north.
This lot directly connects
Parking lot.
Main Street to the park.
Wayne, you want to say something?
I was going to say something.
Just be where I can hear you. You have to,
Can it be here?
Yeah.
Because I can tell Anthony where to point.
What do you got?
So if you point at this lot. Yeah, so the lot Anthony is pointing to is one of the lots owned by Good Ground. You'll notice that extends out to Montauk Highway. But more importantly, all the properties in this area from Montauk Highway all the way to the Good Ground Park to the north are all village business. And at some point, as this board has planned, that they will get developed. But at some point, there will be a north-south access. It will not be on this property, but it'll be on some adjoining property. The property to the west, immediately to the west, up the next lot. That lot is owned by Good Ground. That was part of the Jackson minor subdivision in 1983, where the front lot, that lot has access over that right-of-way right there that Anthony's talking about. And that's where, for legal purposes...
Can you hear him?
You need,
no? You can't. Go ahead.
Sorry.
And identify yourself, Wayne, please.
Again, Wayne Bruin, O'Shea, Marcinsigan Bruin for Good Ground. So that right-of-way provides access to that lot, and for legal purposes, since this lot doesn't have frontage and since it is landlocked, the plan is for us to have an access across our other parcel down over that existing right-of-way.
okay, now,
Um,
where is Good Ground Park and where is the CPF office?
Good Ground Park is to the north. You see the road and the development in that area.
Okay.
The CPF office is down off of Montauk Highway to the east here.
Because I've walked to the park from the CPF office. There's a nice little path.
And it's where that little loop.
There is.
Right.
on this property here.
Okay.
Yeah,
Yeah,
the
you
office is
kinda
just
see
to the
it.
right there.
Yeah, I'm trying to place what I've been physically at compared to what I'm looking at on the map.
So the plan, obviously, as Stan indicated, what this board, I think, has contemplated and what the town board contemplated, but regardless of the town board's plan, this is village business. It will be developed commercially. So the cross-access that we said we would, after the board raised it, we said, and then that's why Stan is here to express the fire district's concerns, we said we would accept it as long as it was east-west only to the north of the recharge basin, and we would agree that there would be no access no matter what. And that was in the covenant that we worked on together, just a sample to discuss, that we would not allow access to Montauk Highway, recognizing the fire district's concern that they want no access across from the firehouse.
So basically, we're saying that this is potential future planning.
It's all future planning, absolutely, and
Okay.
that's what Stan was
Okay,
indicating.
that's kind of what
It would be
I-
in the future when a site plan comes in on any of the parcels,
Yep.
that you, it's been
Understand?
your traditional requirement under your
Yeah.
code and otherwise, but our position is whatever the planning board decides, if they agree with the fire district, what we're trying to do, as you can imagine, 2016, a subdivision contract was signed, there was a referendum by the fire district, and they conveyed the lot. What didn't occur was the actual subdivision approval by this board and the health department. We're trying to get those two done. So it legalizes our lot in particular and the fire district lots to be buildable.
So Wayne, just a question, the immediate property that Good Ground owns to the west, that has access to Montauk Highway.
Right, that has a dwelling.
Has there been any consideration to include that in this subdivision?
Well,
so that you could-
originally, interestingly, wasn't part of the contract between the parties, but shortly after it came to the board, there was an agreement, they did include that. However, and this board actually granted final conditional approval. What you did, though, is condition it on health department approval. Ordinarily, you do your pre-app, get health department, then come with your final map. Here, I think, trying to facilitate the fire district and everybody, you granted final conditional approval subject to health department. And then an application was made to the health department. And that's when everything fell apart, because that original Jackson subdivision approved by the zoning board in 1983 never received health department approval. And then they required the front parcel, Mr. McGuire's parcel, and then the Numjowski, which is 50% owner of the right-of-way.
Oh.
Mrs. Numjowski passed away. She left it to two daughters. They both passed away. They're all out of state. It became impossible to locate and find anybody who could sign and agree to that. In addition, the health department then wanted both Good Ground and the fire district to upgrade the septics on those two parcels. Number one. Number two is also the fire district to give up sewage flow rights on their two parcels to account for all the development on particularly the McGuire parcel, which is retail and apartments in a tiny lot. So they wanted to allocate the flow, and all of that became objectionable. So we said, let's just go back to the original three-lot
Right.
division.
Right.
And that was originally contemplated under the contract. We recognize that the lot doesn't have frontage. We would have to go to the zoning board, but understanding we have access, and then it was this pre-app report that, in this issue that Stan has just
Right.
addressed, that has put us on hold since basically March, I believe. February
So,
1.
so in considering the lot to the west, what the health department's saying is that in 1983, it was part of a subdivision, and that is woefully inadequate, and that you have to upgrade all of the lots in that subdivision.
Correct.
Could you do,
Plus restrict the flow.
right, which
They
would
would treat
affect,
it as if that subdivision didn't occur, look at all the flow that's existing on the entire property.
right,
And then restrict the amount of flow, if we were going to end up with that small commercial lot.
Right.
Is well over the allowable flow They were going to then restrict the allocation of flow to the point where you may recall there were notes on the map that the lots couldn't be developed until sewers were provided. And there's no sewers, but there is the overall plan, and the town's talking about sewers, but, that would,
It could
that
be
was
years away,
approved.
yes.
And I don't think we ever got to that point with the fire district, but it's a similar issue than what was already described, is that they would have to give up their rights to develop that property.
Right,
Not
right.
that they're looking to do that, but still, they would have to give up their rights until sewers were provided.
Yeah,
Yeah, we never got to that.
And we never got to that discussion.
right.
And the original application that had conditional approval was abandoned at that point. We went with the
Free lot.
the one that's pending right now.
And what about the parcel to the, oh no, you'd still have to go over fire department property. I was going to say, the property to the east,
Well,
that Good Ground owns.
Yeah, I mean, it seems to me that it doesn't matter about the west stuff if we're trying to future plan to get east.
Across.
So, and what the conclusion I'm coming to is that you have two options. There's no cross-access in the plan, or there is specified where, east-west, and there's some sort of compensation that Good Ground would make to the fire district to satisfy that legal issue. And then if you have to go to a referendum, then we meet the concerns of the fire district, and we meet the concern of the town for cross-access.
I think if for purposes, if this is just the pre-app report, like, I would just maybe do if you want to get them on their way, which I can understand you may want to do, because it's been hanging out there. You could just put in a whereas and just kind of briefly describe what's been talked about, what we may be looking for, and that it's out there and unresolved, but to be determined. You're basically saying, when you figure it out more completely and you come back to us with a more complete
Well,
map, then we'll figure it out.
I mean, that's a good thing. I would want to see that resolution before we would vote on it, because you'd be taking wording and caveats from Stan's letter, and we would need to see that before we approved it, but.
I wouldn't put in anything from his letter. I would summarize very
Yeah.
generally.
Yeah, but it's what I just said, but in a more legalized way.
And I can work with
To that
both
point,
council to do
Anthony,
that.
I don't think I was included on the email with the letter, so I wasn't able to review that in advance. I don't know if I have a town email yet, maybe, if it's going there. I have to, okay, so if you can get that to me, that would be good. And then, I just have a
It
question.
went from Patty.
Here's a copy, an
Okay.
extra copy.
Thank you.
Print that again.
Patty has you on there, so
Okay.
we'll check it out.
I'll double check.
Patty will check
Patty
it.
thinking ahead.
The other question that I had was if you were looking at this parcel as a planner and not with the context of this agreement that was made on the side without an actual subdivision approved, what would you do with it? What's the correct way to
Well, put it,
divvy it up into three parts?
I think the report says it, we
Sure.
normally just, require or, the cross-access.
Mhm.
I think, what I would say in this particular case is, and I hear Stan's, arguments, and I get it, and I think that to be resolved, but I think, if we could get an extension, I could make revisions to the report, but I think what we do is identify the objections that were raised by the Hampton-based Fire District, and note that they would have to be resolved before.
Can you use the microphone, please?
Sorry about that. That we would identify the issues in the report, and that these issues would have to come to some legal conclusion, an agreement before the planning board would be able to consider approval of the subdivision. Am I saying that correctly, Christine?
Right. So in other words, we have an active pre-app out that has to be modified to include comments from the fire district. And we passed that pre-app. I mean, pre-app is a pre-app. You objected, though, to the pre-app
I did.
without the language in, but we would include language in it to reflect what your comments.
Objections, yes.
Right. And then we would have that out there. I don't know if it resolves anything, except it moves it along in the process of the planning board. Otherwise, we keep extending it and extending it and extending it, and no one is served by that. So if you'll give us an extension for this, Anthony can amend the pre-app report, and then we can bring it back the next session and pass that, and then you'll have to work it out as best you can. It's a very tricky situation.
Okay.
Fine.
Okay?
Good.
Just one comment before you go. You mentioned the fire department has concerns with safety with cross-access. In the event of a purchase, that safety issue remains. So I'm not sure how purchasing the land would then automatically make those safety concerns vanish. So I think the safety concerns either are there or they're not. So I think we need to make that determination because a purchase is not going to rectify a safety issue if one exists.
Actually, one of the things that I mentioned in the letter, because I tried to give a complete overview of everything even that preceded the sale in 2016, is that there had been some discussion with the town about the district possibly entering into an agreement allowing Lot 3, or part of Lot 3, to be the pedestrian walkway to Good Ground Commons, either by agreement or perhaps by the town purchasing that lot. And those discussions continued in good faith for quite a while. It was my board's understanding that it would be only be pedestrian. However, after receiving that representation, we became aware at a town board work session that was videoed that there was actually planning being done by Kyle Collins, who was in office at the time, or in position at the time, that it was not really going to be pedestrian. It was going to be vehicular traffic, all coming right down from...
In front of you.
Right in front of us. And that's basically when the discussions ended.
Oh.
Yeah.
Okay. So it wasn't that, I don't want the impression to be left that the district has been obstinate or, they're trying, but that's what happened as far as the sale.
So if that were to revert to a pedestrian piece, would the district consider it? It doesn't help you, though. It doesn't help the subdivision.
No.
No.
And that was,
Conundrum.
yeah, I mean, that was something that the Trails Advisory Board was saying they would like, because then that gave a really good access to Good Ground Park from...
On foot.
Theoretically, it would have, yes.
Yeah, would have.
Yes. The other thing, I'm not 100% certain about this, but I believe that there was recently another roadway into Good Ground Park that was dedicated, coming from...
West side of the parking lot.
Not from Squiretown, but from, well, maybe from Squiretown, yes, into the park.
Yes.
Is that right? Mm-hmm. Okay. So I don't know what impact that has in terms of there being access from the north to lot number 2 with that additional access point into the park. But that's something that Chief Capers mentioned in his affidavit.
Oh. Okay.
So,
All right, so can you give us an extension?
Do an extension until
Yes.
September 8th. I'll draft up a revised pre-app report, send it off to the planning board to make sure that Wayne and the applicant. Yeah, I have to work on it and send it out.
We have a very heavy agenda set September 8th, so.
Okay, or the 25th, that's up to you.
We do
25th.
25th, it'd be better for us.
That's fine.
Great.
So for the record, the applicants will consent to the adjournment to your second meeting in September, and I'll just, for the record, send a letter in consenting to that.
Great.
That's agreed.
Thank you, thanks so much.
Thank you all very much.
Thank you.
Good.
Okay.
Look, you agreed on something.
You made us use our brains.
Thanks for your help.
Thank you. So
Thanks for your
there's-
help.
Thank you, Stanley.
Thanks.
So there's no action on that.
It
Oh, an
actually, just do an extension until September 25th.
Okay, so motion for an extension to September 25th?
Motion.
22nd. Motion by George, second by Craig, all in favor.
Aye.
Opposed, abstention, 6 in favor, 1 absent. Okay, so moving-
Charles Terra, this is a lot line modification. The property is in Noyak, you have Oak Drive here to the north, and Mill Road here.
Number 3?
Speak into the mic.
Oh,
Voice of God
I'm
is
going to get
next.
yelled at, you're right.
Mic.
So this is a lot line change application involving the two properties here in New York. It's actually a very simple application. Basically, the lots are configured here, pink and blue. And a portion of the blue lot here is going to merge with this, so you get basically two equal-sized lots. I believe the zoning is R15, so no variances were needed. It didn't involve any setback issues. So it's really just a simple land transfer between the two properties.
Were they both conforming to start with?
They are both,
No, the northerly one's
oh, that's right, you're making it. But the other lot still remains conforming then.
That is correct.
Right, one lot is non-conforming, it's becoming conforming. The other one is conforming, remains conforming. So we'll have two conforming lots. So that was it. It was a pretty straightforward application, no additional density, existing residences on each. So I have a resolution of approval. We typically just do simple lot line changes as an approval. I did the referrals as we normally would, and rather than go through the few that we have, I'll just go right to the resolution because any of their comments have been incorporated. So I would recommend approving the lot line change, subject to, let's see here, sorry.
Health Department approval?
Health Department approval. As 2 and 3, the town engineer had no issues, but noted that there's an irrigation well on the north side there, and a fence on the east side within the right-of-way, so they would just have to be removed.
What is an irrigation well from the health?
Irrigation well, for the landscape.
Privately owned by.
They would just move it back onto their
Can you
property.
please give us your name for the record? You know, I know you're comfortable, but you can come here.
Bruce Anderson, Suffolk Environmental Consulting.
Thank you.
I've read this, we're all in agreement.
Good,
It's
thank
fine. Thank you.
Same thing with the fence, just needs to be relocated onto the property. And then 4 is the submission of the draft deeds that we would require representing the change in the lots, execution of the property transfer via 3 deeds, 1 transfer deed executing the land transfer, and 2 confirmatory deeds for each of the resulting parcels. Typical covenants that we require in this case, we would still do the 3-inch drainage for future pervious surfaces per the town engineer, and no further subdivision without planning board approval. And then, of course, the title certification, mortgage consent, approval of the documents, submission of the final maps with the health department approval, and then ultimately the filing of those maps.
Could they come in for a building permit for a pool after moving the lot line? And since it's out of conformance, how would that work?
They would be able to go get a permit to construct whatever they wanted, you know, within the confines of the setbacks and everything, so.
Or they go to the ZBA?
Well, but the setbacks will be appropriate then, even because the house was built closer to the road.
It was. My guess is it's bringing the property into conformance with the lot size. So it would give them an opportunity to put an accessory structure on here without the need to getting
Because
variances.
it's R15, right?
Because it's R15.
Yeah. Bruce?
Yeah, there's no issue with dimensional setbacks.
Okay. All right. Any other questions from the board? Okay, everybody. So this is an action deadline,
So it's just to approve the conditional approval of the lot line.
okay? So can I have a motion, please?
Motion?
Motion by Gloria and second by George, all in favor. Opposed, abstentions, 6 in favor, 1 absent. Thank you.
Thank you very much.
Anthony, you're up to 911 Flanders.
That's the, an extension for the 7-Eleven project in Riverside, and it's a secret determination extension until September 8th, 2022.
8th is going to be one.
It's, be prepared.
Well, the 8th at night is going to be, you
Bring your sleeping bags.
Yeah, it's going to be the 8th and 9th.
know, yeah.
Bring jammies.
Okay, extension, so motion to,
Motion?
motion by Craig, second
Second.
by George, all in favor.
Aye.
Opposed, abstention, 6 in favor, 1 absent. Extension to September 8th.
Number 5, we did. Number
did
6
5,
is
number 6.
Tuckahoe Orchard. This is a new 2-lot subdivision located at 268 North McGee Street, Tuckahoe. It's in the R40 zoning district in New York State Archaeological Sensitive Area. I've outlined the lot here. And just to show behind the lot here, you have town-owned open space immediately adjacent to the property. I believe this is town-owned too, but well, it's owned by the town or the county, but it's preserved land. The applicants come in with a 2-lot subdivision, showing a yield of 2 lots, showing the steeper slopes in the property. And then they came in also with a cluster plan showing the 2 lots located up here with 25%, which is the minimum open space requirement for this property in the zoning district, in the back to connect with the existing town-owned open space, hopefully.
Do you have those maps there?
Yeah. Hopefully, putting the open space back here sort of sets the stage for the other couple of lots in this area. But this would be probably where open space on this property would most make sense, would be back here, adjacent to the existing.
Yeah, it looks like it's a lot more clear than everything else around it.
Yeah, there had been some activity on the property. And,
Was it being used as a nursery?
it might have been used as a nursery at one point. There were trucks and all sorts of stuff all over the property. These are new aerials, and I noticed that between 2021 and 2022, all the stuff has been removed. Right, Wayne? Absolutely. But, we'll look into it, but it looks like there was some type of plant nursery that was operating out of there. But this is, a pre-application, so any issues, obviously, we'll address. So just to show you again, Jackie, that we showed the yield plan showing 2 lots, and then this cluster plan showing 1 lot here, 2 lot here, and then the open space in the back.
Right, which makes sense, yeah.
Neither one has a house on it?
There's no homes on the property.
Okay. And you mentioned slopes, so can they actually build?
They can. They showed the steep slopes. They actually did give us a slope map. And what we'll do is, as part of, our pre-app, if we need to limit building envelopes or ask for, we will certainly do that. But they did give us the slope, so that was good. So I'm going to recommend that we deem the application complete and schedule the hearing for, I don't know what I said in my resolution. October 13th, 2022.
Okay, Anthony, I also made the request that when we're looking at McGee Street and some of these applications, that we look at all of McGee Street now, because there's a lot of development going on in terms of traffic.
I think this is way north, isn't it?
Is it?
Yeah, this is north.
Way north.
It is
It's
north,
not
yeah.
down further.
Yeah, no,
where
it's not.
No,
Near the intersection. But yet and still, we should be aware of McGee Street.
there's a lot of activity going on, for sure.
Okay, so motion to deem this complete and schedule a hearing on October 13th.
Motion.
Motion by Gloria, second by Tom, all in favor.
Aye.
Opposed, abstentions, 6 in favor, 1 absent.
Number 7 is Radziwill. This is an application I took over for Matt. This was a lot line change application involving this subdivision over here. They've been asking for extensions on adopting the pre-app report because I believe
Is this off of Ocean Avenue?
this is off of Ocean Road.
Okay, yeah.
Yep. But they've asked for another extension of the action deadline until
November 23rd.
November 23rd, 2022. They're trying to work some stuff out. My understanding is, and I apologize, I just took it over, with the zoning board, so they're waiting to resolve that before we proceed with this one. So they said November 23rd.
Motion for an extension to November 23rd.
Motion.
Motion by Craig, second by Gloria, all in favor. Opposed, abstentions, 6 in favor, 1 absent. Parrots Project Management.
Berries, so this is another one where we have a, let's see, definition, it's another lot line modification between these two properties. I don't have the map, my apologies, but it's just an extension to get you already did an approval of this, so they're just waiting to get their final maps. What happens with these lot line changes is we condition, unlike a subdivision, we condition it on health department approval. So what happens is you get through the lot line modification process pretty quickly, and then you're stuck in the health department
Exactly.
for however long. So
So this September 18th.
18th, yeah,
It's a bad date, right?
Yeah, no, because they were late getting it to me, it only goes until September 18th, so they're going to have to come in for another one. We can only do them in increments of
6
90
months?
days, yeah.
Oh, 90 days. So when are they coming in? When is it extended to?
It's September 18th.
Because they were late in
Okay.
submitting the request.
Yeah, it's retro, yeah.
Okay. So motion to extend this by George, second by Gloria, and all in favor. Opposed, abstention, 6 in favor, 1 absent. And 9 is 890 Scuttle Hole.
Yeah, if you recall, we were looking at a subdivision on 890 Scuttle Hole Road, really involving just a 2-lot subdivision of the property in the front here, and then sort of memorializing all of this property back here. Remember, this was all a development rights sale. One of the early ones started in the 80s, and they had been selling the development rights since, up until like 2000 or something, or 2010. So we did the pre-app report on this, and they're still working stuff out, so they just asked for their 1-year extension on the pre-app report.
It goes up, the property goes up to another road.
Yes.
I believe. What is it?
That is Noyak Path.
Noyak Path.
North Path.
Yep, Noyak Path.
Yeah.
So this would be an extension until August 26, 2023.
2023. Okay, motion?
Motion.
Motion by Gloria and second by Craig. All in favor?
Aye.
Opposed, abstention, 6 in favor, 1 absent.
And then just on the signature, the Woods, I don't have actually, but Jet Cab, I do. So we'll just acknowledge signature of Jet Cab LLC.
I don't have Jet Cab.
I know, I added it on.
Jet Cab signature, so we're acknowledging that. Jet Cab
It will
signature.
be signed as soon as we
Okay.
finish here.
Is the Woods off?
The Woods is off, yeah.
Woods is off. And that's it. We've done it. Okay, motion to adjourn.
Motion.
Motion by Gloria, and second by George. All in favor?
Aye.
Opposed, abstentions, 6 in favor, 1 absent. Great, see not everybody tonight. Florian and Kate will be here, you'll be here, I'll be here, Craig will be here. We have a quorum.
Good, thank you.
Great.